Welcome to Constitutional Chisme.
Law Daddy's Guide to the Legal Basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure to pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one.
This episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan for bar prep, be sure to use our code PASSWITHPawns to save an additional $100 off your course, as well as 20% off of any additional bar prep supplements. Using this code not only saves you a little bit of money, but it also helps the podcast and make sure that we can continue to give away free bar prep each cycle through our partnership with Cap.
We also have a new partnership, and it's one that Harleigh and I have been really working on getting because we want to help save you guys money. We're able to get a discount code for you guys. Now, that'll save you money on your LSAT course. However, sometimes they have sales that are better than what my discount code can do. And unfortunately, this one does not stack. But a way that you can support the show is to go on our website, which we just launched today, called legallyponzanellypodcast.com. And if you go and look up Kaplan on our website and click the link there, that actually helps us so that Kaplan knows that our audience hears us and knows that we are trying to help you guys save money for the Kaplan LSAT. There will be a link. So if you go to our website that we just launched and we're really excited about, and I can't wait to talk about it with you guys, you can click the Kaplan LSAT link, and that gives us some help as well.
The website looks incredible. Stephanie did such a good job on it. Give her all the flowers. It looks amazing. Her and her mom designed a lot of the goodies that you may or may not be able to find on the website. But everything, putting it together, was all Stephanie, and she did an incredible job. So go take a gander at it and check out some of our resources, get a little bit more information about who we are. You can find links to every episode across the Legally Ponzanelli podcast, every episode of Constitutional Chisme, and I don't know, maybe a few other goodies. You should go look and see what you can find.
Yes, we launched merch, and I may be biased, but I do think it's the cutest law merch ever. So definitely go check it out. You're going to love that. We do also have a spot where you can sign up for our monthly newsletter. And what we'll do with the newsletter is give you guys information on the guest speakers that we have coming up, any resources we feel like, oh, this would be good to share. And also any discount codes, sales, anything that we can find for you guys to save you guys some money. We are going to get that out to you guys, and we're going to make it super easy. It'll go straight to your email. So you can check that out, go to the website, and let us know what you think, because it is a lot harder than I thought it would be to create a website. I don't know why I thought it would not be this hard, but it really was.
Stephanie was screaming, crying, throwing up. But you know what? Every second of it was worth it, in my opinion, because it looks beautiful.
Thank you. Yes, I'm excited. I loved the merch. I loved doing that collab with my mom, and that was really fun. So yeah, check it out.
Okay, are you ready for today's case? Because I don't think you are.
I think I'm ready.
Okay.
I don't know what it is, so yeah.
So this is kind of a crazy one. This
Okay.
is an evidence case.
That's going to be crazy.
Okay. Listen, you would think no. You would think it's evidence. What?
No. I would think yes. It's going to be crazy.
Really?
Yeah.
See, going into evidence as a class, I thought it was going to be as boring as everyone said civil procedure would be. Now, I love civil procedure. Everybody who says it sucks is wrong.
That's crazy.
I'm looking at you, Stephanie.
Oh.
So I assumed evidence would be the boring class that everyone told me civil procedure would be. It was not. One, thanks in part, one, to the amazing professor I had, and two, the cases go crazy.
Yeah, they
And
do.
this is how my semester in evidence started. So today we're going to be talking about Tanner versus United States. Exactly. Thanks. Exactly.
Just so you know, the audio doesn't
you hear
catch your
him?
cat, so it just sounds like you're talking to yourself.
Perfect. I am. I actually don't own cats.
Bro, that's crazy.
That's crazy. Okay. I'm going to back up a little bit to give you a little bit of context into the underlying case because it was a criminal case initially. So this all started with Rural Electrification Administration, or REA. So they had the rights to supervise this project and to approve certain contracts, including a road construction agreement. And what exactly they were building is not particularly important for any of this. But what you need to know is that Conover, who's one of the petitioners in this case, was manager of this company called Seminole. And he was friends with the other petitioner in this case, Tanner. And they had been in business together for several years. So Tanner's company was awarded the contract for the construction of this road that REA was building. So Tanner's company got the contract for the construction of the road based partially on these bidding specifications that Conover's department put together. So essentially, Conover, this one guy, helps Tanner get this contract so that he can build the road. And as a little thank you, he gave him $30,000.
Oh, wow. I need a little thank you.
I need a little thank you. And so, but he said allegedly that these are just payments for personal transactions, that it was unrelated to this whole contract.
Well, then what would the personal stuff be?
Exactly. Don't worry about that.
Yeah.
So Conover ultimately helped resolve some problems that came up between Seminole and Tanner and kind of made sure that everything worked out in Tanner's favor, even though he worked for Seminole. And REA starts to complain a little bit that Tanner's bond was not from an approved company. And all of these things are kind of going crazy. Conover is trying to cover for him and sends all these letters saying that this new bonding company had misrepresented the road's state of completion. Yada, yada, yada. There's a lot of shady things going on with this contract.
I think I'm confused.
I'm confused. Girl, you're confused. I'm confused.
I'm confused. Okay. Just let me go back to make sure. So for this person made a bid. And for the listeners, that is like, hey, if you hire me, this is how much I would charge. And whenever people get a lot of bids, they decide from there who to hire, right?
Yes.
And so his friend ensured that he would get a bid or he would win the bid, right? Is that what it's called? Win the bid?
Yes.
I don't know.
He made sure that he would win the bid.
Okay. And then gave him, and let me make sure. And so for winning the bid, he gave him $30K and was like, here's my thank you.
Yes.
Allegedly.
Yes. So yes. So basically, Conover uses his position in Seminole to help out his friend. And then his friend goes, thanks for that. Here's $30,000. So because the underlying project for all of this was for the Rural Electrification Administration, which was a department of the United States, Tanner and Conover got indicted and convicted of 1, conspiring to defraud the United States, and 2, committing mail fraud. These are both federal offenses.
Oh my gosh. That means we're going to be in federal court.
We're going to be in federal court. So they were indicted. We won't get into the specifications of mail fraud and all of that, but the code they were indicted under was 18 United States Code, Section 1341, which essentially just makes it a crime to use the United States Postal Service or any other private carrier to carry out a scheme to defraud people of money. So in some way, shape, or fashion, they were using the mail system to carry on this little sideways deal they were doing. Now, here's the funny thing. none of those criminal things really are at the heart of what this case is about.
Oh, okay.
So they get convicted, but between getting convicted and being sentenced, the petitioners filed a motion seeking permission to interview the jurors. They wanted an evidentiary hearing, and they wanted a new trial based on a trial juror's statement that several jurors had consumed alcohol throughout the trial, which had caused them to sleep during portions of the trial.
I feel like if I was a juror and it was really dense and boring, I wouldn't need alcohol to fall asleep. That's all I have to say about that.
That's all I'm going to say on that matter. But here's where it gets a little kooky. Okay.
Mhm.
So I'll go ahead and tell you that the lower courts both said, no, you're not getting a new hearing. And it makes it up to the Supreme Court. Okay. So the interview with the juror who came forward. Sorry, it's not funny. It's a little funny. So he specifically said that he felt like, quote, the jury was one big party. So he specifically said that 7 of the jurors drank alcohol during the noon recess. So like when they would go out to lunch.
How did they know?
And
did they have someone like watching them?
No, this is one of the jurors that came forward and was like, I feel bad. I need you to know that this was happening behind the scenes. And they
Not
want
a snitch.
to literally. And he's like, at least 4 jurors had consumed, quote, a pitcher to 3 of beer during the recesses.
Wow.
And then on several occasions, he had observed 2 jurors having 1 or 2 mixed drinks during the lunch recess.
Was he just sitting there counting everyone's drinks?
He's just counting. And he's like, and the 4 person had a liter of wine on 3 different occasions during the lunch break.
Oh my God. That's not funny. It's just like crazy because I feel like I would not be like counting how much everyone's
girl.
Oh,
we're not done.
Okay. They were drinking more. Okay.
No. So he said specifically that he and 3 other jurors also smoked marijuana regularly during the trial. So they would leave during recess. Yes, they would leave during recesses and they would smoke marijuana during the trial. And then he observed at least 1 juror ingest cocaine 5 times and another juror ingest cocaine 2 to 3 times. He then also told about how 1 juror sold a 1/4 pound of marijuana to another juror during the trial and had brought marijuana, cocaine, and various pieces of drug paraphernalia into the courthouse.
Okay, so they were a party group. I do give them that.
They were partying hard.
Yeah. How did no one notice?
Well, we're gonna get into that. So he also said that some of them were falling asleep during the trial, but at least 1 juror had described himself as flying during the trial. And so, like I said, this juror said that he came forward, quote, to clear my conscience and, quote, because I felt that the people on the jury didn't have no business being on the jury. I felt that Mr. Tanner should have a better opportunity to get somebody that would review the facts right. So
but he was also doing bad things.
But he was also doing bad things. So
okay.
Take it with the grain of salt that it deserves.
Yeah.
So it's on these facts that they brought forward their motion before sentencing, and they said, we want a new trial and an evidentiary hearing. And the court said no, and then it made it up to the Supreme Court. And specifically, the majority of the court's analysis turned on the interpretation of the Federal Rules of Evidence 606B. So Rule 606B states, and it's a little wordy, stay with me, quote, upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon his or any other juror's mind or emotions as influencing him to assent to or dissent from the verdict or indictment or concerning his mental processes in connection therewith, except that a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror. Nor may his affidavit or evidence of any statement by him concerning a matter about which he would be precluded from testifying be received for these purposes. That's a lot. Here's the short and simple version.
Thank you. You lost me.
Essentially, a juror is not allowed to testify about the deliberation process. He can't go in there and talk about what the jurors were thinking or how they felt when they were choosing whether or not to indict somebody or whether or not they chose to find the person guilty or not guilty. A juror cannot talk about any of that. The exception being a juror can talk about extraneous prejudicial information or outside influence. This kind of the stereotypical thought is, think about how juries are sequestered. They're not supposed to read any media about the case. They're not supposed to talk to anybody about the case.
Mm-hmm.
If for whatever reason the jury was like, I saw so-and-so on their phone Googling this guy, that's something that they could testify to because that is now extraneous prejudicial information that has come in.
Because it's outside information, but within each other, they can't tell on each other kind of thing. Is that what you're saying?
No. They can tell on each other, but they can only tell on each other about things that have come in from outside of the court that have influenced them.
Oh, okay.
So the outside influence here would be whatever they're reading on Google. Whatever's on Google may or may not have been introduced in court, and that could be prejudicial, extraneous information that has now come in. Because in theory, a jury is only supposed to consider what has happened in court, not anything that they can find themselves online.
Is that why people get upset or they try to move a case sometimes because they're like, there's no way everyone in this town wouldn't be biased?
Yes, exactly. So a jury can't be asked to testify about what made them decide the way they decided. But a juror can be asked about something that influenced their decision that was not part of the actual trial process.
Okay.
Does that all follow? That makes sense? Okay, perfect. So I think you can kind of see where this is going. So petitioners argued that the substance abuse, the alcohol, the marijuana, the cocaine, was an improper outside influence. So jurors can testify about it under Rule 606B. So they're saying it falls within this, that's an outside thing that came in. The drug usage is coming in from outside of the courthouse and has now influenced the way that they may or may not have looked at this case. So they can testify to it. It falls into the exception. However, the Supreme Court did not agree with that. So in a 5-4 decision, the court said the language of the rule cannot easily be stretched to cover this circumstance. However severe their effect and improper their use, drugs or alcohol voluntarily ingested by a juror seems no more an outside influence than a virus, poorly prepared food, or a lack of sleep.
Yeah, that all seems to be very similar.
I mean, if they're a little sleepy because they had a glass of wine at lunch, the court's basically like, I don't see how that's any different than they didn't get a good night's sleep the day before. And after lunch, you're a little tired.
And the cocaine makes sense because that would wake them up.
Exactly.
Like a coffee.
They needed that. They needed an upper after the marijuana and the alcohol. They were like, geez, I'm falling asleep.
Honestly, can you blame them? I get it.
This is also the 80s. Okay. I say with all love, this did happen in the 80s. So the court also looked to the legislative history of the rule. And specifically, they looked at the Senate report, which stated, permitting an individual to attack a jury verdict based upon the jury's internal deliberation has long been recognized as unwise by the Supreme Court. Public policy requires a finality to litigation, and common fairness requires that absolute privacy be preserved for jurors to engage in the full and free debate necessary to the attainment of just verdicts. Jurors will not be able to function effectively if their deliberations are to be scrutinized in post-trial litigation. In the interest of protecting the jury system and the citizens who make it work, Rule 606 should not permit any inquiry into the internal deliberation of the jurors. So with that language, the court said, we cannot go back and second guess what the jurors have done here if there was not something incredibly prejudicial that influenced their perception of this case. What they were choosing to do behind closed doors does not necessarily lead to prejudice in a way that we should now be scrutinizing the jurors. So we're just gonna call it what it is and walk away.
I feel like that's interesting because here's the part that I kind of struggle with, where I'm like, okay, but it's also illegal to do these drugs. And so you're knowingly dismissing that what they're doing is not legal. And like the drinking, like, I know that's not illegal, but like, I don't know. It just feels weird. What do you think?
No, I completely agree. And I guess it does kind of go into the whole privacy of if people are choosing to break the law, people are choosing to break the law. But you are choosing to break the law in a federal courthouse. And that is certainly a choice.
Yeah. Because like, could they
You
get
are
charged
choosing,
or?
no, not without some evidence, because it's technically not a crime to do drugs. It is only a crime to possess drugs.
Oh, okay.
So
This is not legal advice.
This is not legal advice. We are not your lawyers. Possession is a crime, but like if you're under the influence, that itself is not a crime unless you're operating a vehicle
So
or causing a disturbance. But
I mean,
that's
but didn't you
a
say
public disturbance.
yeah? But didn't you say like someone was literally selling in there allegedly?
That is in fact a crime. Again, but that's alleged. And if there's no evidence of that other than this guy's testimony, and fun fact, he now can't testify about it because it's part of the jury deliberations.
I
He
didn't
can't
realize
talk about
that.
what's going on behind closed doors.
So what do you think happened to him after this? Like, were they like, wow, never be on jury duty with that guy?
No, literally. Well, so petitioners did make a second argument, which I think is a little bit of a stronger argument, but obviously the Supreme Court did not buy this argument either. One of the things that they brought up was the Sixth Amendment, which specifically is supposed to guarantee you the right to a fair and competent jury. And so they basically made the argument that you cannot say we had a fair and competent jury if there are allegations of substance abuse occurring during the trial and during deliberations.
Yeah.
So the Supreme Court also kind of kicked this. They were like, this doesn't work either. And basically they said, again, long recognized and very substantial concerns support the protection of jury deliberation from intrusive inquiry. The suitability of an individual for the responsibility of jury service is, of course, examined by, hold on, let me back up. Petitioners' Sixth Amendment interest in an unimpaired jury, on the other hand, is protected by several aspects of the trial process. So they're basically doing kind of a balancing test here to say there's these very substantial concerns about protecting jury deliberations. And this is the one and only way we can protect these jury deliberations. On the other hand, the Sixth Amendment is protected by several steps in a very long process. So, for instance, you start with determining the suitability of someone for jury duty during voir dire. Voir dire.
Voir dire. What is that?
I said voir dire because I've been in Louisiana too long, and that's how they say it. It's voir dire. Voir dire. Voir dire is the process of jury selection. Essentially, it's where you question all the people who've been randomly selected, and you narrow it down to the jury members that you want.
Okay.
So you have that whole process where you're able to ask whatever questions you want. You have so many ways that you can rule jurors out, be it through, oh my gosh, I'm totally blanking on the word. Anyway, there are several ways that you can exclude a juror from service prior to the start of a trial.
Yeah, there's the preempted, right?
Yes, preemptive strike. Thank you. I could not for the life of me think of that phrase. You have preemptive strikes, and then you can also get rid of jurors for cause. if they have a particular bias against one party or the other. There are
Yeah.
several mechanisms within a voir dire to get rid of someone who is not fit for that particular, to serve as a juror for that particular case. I keep saying get rid of, which sounds so violent for some reason. It sounds like you just kick them out of the court. You dismiss them. That's a better word. You dismiss them from service.
The preempted ones, you only get 3, right?
Yes.
And those are, you can do 3 of those, no questions asked. However, you can't do it while being like sexist, racist. There's a couple of things that won't fall under.
Okay, bar exam.
Okay,
criminal procedure.
I don't know why, but I am the crim pro queen.
Do you remember what the hearing is if you think that someone was doing jury selection improperly? Do you remember what the hearing's called?
Oh, no, I don't.
I think it's a Ferretta hearing.
Well, I definitely didn't know that for the bar either.
Nope, Ferretta hearing is what's wrong with me.
I was like, I don't know that.
Ferretta hearing is when you determine if a criminal's request to represent themselves is a good idea. That's the only way I can think to put it. Oh my god.
I really don't remember what that's called.
It's a Batson challenge. Oh my god.
Okay, yeah. I vaguely remember that.
A Batson challenge. Jesus. Sorry. My head is empty. It's late. Anyway, so you have the whole voir dire process during the pretrial phase. Then once the trial starts, the court said, quote, the jury is observable by the court, by counsel, and by court personnel. So they pointed specifically to a case out of California where a U.S. Marshal discovered a juror who was smoking marijuana during the early morning hours.
Mm-hmm.
And that juror was dismissed because it was observed by someone during the trial process. And I think that is the most important part here, and what the court placed a lot of weight on is the fact that these issues only came up after the jury had found them guilty.
Okay. And this was someone found out before, right?
Yes. So the case that they cited out of California, which was United States versus Provenzano, I think is how you would say the name. That was someone who was discovered during trial. So this is prior to a verdict actually being rendered. And again, to this same issue, the court pointed out that jurors can also report each other for inappropriate behavior prior to the verdict coming out. So there were several mechanisms that existed before all of this happened, before they were actually found guilty. But now that they've been found guilty, we don't now want to call into question a decision that's already been made. Before, yeah, sure, we try again, we pull new jurors, we do what we have to do. But once that decision has come down, a hard line gets drawn by 606 that says, unless something improper happened that was specifically outside influence, they're not allowed to testify.
What was that? Do you remember this case? Sorry, it just made me realize that. There was like someone doing something. I think they were wearing like a ridiculous outfit. It was like a juror or something. And they kept trying to talk to the juror and then she would ignore them. You don't know what I'm talking about? I have no
idea what you're talking about.
And so she got dismissed as a juror, but she was trying not to get dismissed, but she was like wearing something that and like the people were trying to talk to her and stuff.
No idea what you're talking about.
Okay.
What class was this from?
No, I saw this on TV.
Oh, girl was watching an episode of like, I don't know, I can't think of a sitcom now. The Office.
Yeah, it was a juror named Barbara who dressed up in full Star Trek uniform.
Excuse me?
This was in Little Rock, Arkansas.
Why did she do that?
I don't know. Barbara dressed up in full Star Trek uniform.
Good for you, Barbara. Slay.
In Little Rock, Arkansas. Isn't that hilarious? I was like, I know I've seen this somewhere. Like, I sound crazy, but I know I've seen this. And she was eventually dismissed, not because of her costume, but for talking to a TV show.
Okay. Not for the costume is crazy.
Could you imagine? You're like, your life depends on it. And this person is dressing up as a instructor.
Consider that. Like, you're facing, like, I don't know, you're facing capital murder charges. Yeah, the death penalty's on the table. And somebody dressed like a Star Trek character is sitting on the jury. That would be it for me. That would be it for me. Ask them again if they have a plea for me. I don't want to do this anymore.
My God, that's funny, actually. Sorry, I was like, I remember something really wild about
I fully
jurors.
thought you were delusional. I thought you had lost your ever-loving mind.
Will you please Google what this woman, like, was doing? It's so funny.
Say psych right now. This is in 1996, Queen.
Before we were born.
This is actually crazy. What an
wonder-
icon. Barbara
I wonder
Adams,
what made
the
you remember
icon you
this.
are. That's what I'm saying. What made you remember something that occurred before we were even alive? There's a guy on Reddit who has a signed portrait of her. That's so funny. Anyway, okay. Anyway, back to the case. She looks iconic though. If y'all are listening,
No,
you should
yeah.
look up a picture
She
of
is
her.
that girl.
She is slay the house, boots down, Houston, I'm deceased. She rocked that fit. I don't know what to tell y'all.
Meanwhile, the person on trial for murder is like, please take this seriously.
Please, I'm begging. Okay.
Like, why is the media caring about her and not me? I don't even know what the case is. Like, I don't want people to think it was.
I was about to say, I don't know what she got called to jury duty for. Hold on. I cannot read this case. Y'all have me so confused. She's from Brooklyn originally.
What was she doing here?
I don't know. Okay. The newspaper article doesn't say what the...
This is what I'm talking about. That's what's sad. It's like, we don't even know what this case is. It's only that she wore this outfit. But I guess if you dress up...
Whoa. I did find it.
What is it?
It's the Whitewater case? That's
Say
crazy for her to have shown up for that case.
What? Oh, yeah, I just found it. Judge Beam's Trekkie juror from Whitewater case. That's crazy. Did you see that?
Hey, so that's actually insane. Hey, so this is actually insane. This was a federal case. She showed up to federal court.
Okay, apparently people are doing all the crazy things in federal court. We have jurors that are doing drugs all day long.
Okay, you know what? Fair enough.
So, yeah, sorry that we got sidetracked,
so this was actually
guys.
a really important case.
Yeah, we will have to cover that case later.
We're going to have to cover that case another time. That's actually insane. Okay, wrapping up Tanner.
Mm-hmm.
There were technically two issues, but the important one for evidence purposes is, did the district court have a legal obligation to conduct an evidentiary hearing or allow juror testimony regarding the consumption of controlled substances and alcohol during the proceedings? And the court ultimately held that the district court acted within its legal bounds by declining to convene an evidentiary hearing where jurors would have provided testimony regarding the consumption of alcohol and narcotics throughout the trial proceedings. And the ultimate rule that came out of this case is that under Federal Rule of Evidence 606B, a juror is generally barred from testifying to impeach a verdict unless the inquiry concerns whether an improper external influence was exerted upon the jury. And that is the absolutely wild case of Tanner versus United States. Absolutely wild is crazy, but it does sound like the jury was wild.
Yeah, but I think you made a really good point where evidence cases are just kind of wild sometimes. You're like, wait, what? They got away with all of that?
They got away with all of that. And also, like, I don't know, there's just instances where really interesting nuances come out because the Federal Rules of Evidence are kind of fun. And there's lots of weird little quirks about them. And they come out.
So many exceptions.
So many exceptions to the exceptions because life is weird and life doesn't always fall in these cute little boxes. And the rules of evidence and the cases about them have tried to make the rules make sense with real life. And they don't. I'll just go ahead and tell you they don't. But anyway.
Well, that was amazing. Great job. Sorry I sidetracked everyone. I just had a core memory come out.
Core memory is crazy. I need merch that says, like, I don't know, like, party like you're on the Tanner jury. Dress for the job.
You'd be the only one that buys it.
Dress for the job you want. And then it's a picture of Barbara Adams as a Star Trekkie.
So funny. I do want to tell the audience some top news. So our girly pop queen, Cardi B, dropped a new song.
And it's so good.
I have listened to that on replay. I have imaginary beef. I want to do that imaginary beef TikTok where it's like me to that person I'm beefing with because it's so good.
No, listen, just know that I am rolling up to the federal courthouse every day the last 2 weeks with my whole Toyota Corolla shaking from how loud I'm blaring this song. I know that the court security officer is sick of me. I know they're sick of me.
I know they memorized the song.
I know they hear me coming 2 miles away.
No, because the song is so good. I'm obsessed. I love Cardi B. She is that girl. I know every single word from the song.
And you know what? It's actually so funny that we're recording this after Cardi B dropped a new song, and now we've got the website and all that stuff coming out when we came up with the idea for this part of the podcast right before a Cardi B concert.
That just means we're destined to meet her, I guess.
That's what I'm hearing. Cardi, call me. You have my number.
Cardi, if you want legal representation when I'm eventually licensed, you got it.
You have no idea how good we are.
I also may not be able to represent you because I would maybe only be licensed in Arkansas. But if it's here, I got you.
You can transfer. You can transfer.
Or federal court, right?
Yeah, you can do federal court. As long as you're barred somewhere, you can do federal court. And you can transfer. New York is a UBE state.
Okay. Cardi, if you're hearing this, Harleigh and I will quit our jobs whenever
Stephanie will quit unemployment.
I will quit unemployment to go and work for you. Okay. No one will ever care as much as us. I promise you that.
Well, until Cardi calls us, I guess we'll just keep making a podcast. So thanks for listening to this one, and we hope you listen to the next one.
Yeah. We'll talk to y'all later. Bye.
Bye.